Can you hear me now?
Yes, I can hear you now.
Okay. I'm sorry. Was I on mute the whole time?
I guess so.
Okay. Let me welcome everyone to the webinar, Asian Americans and Loyalty. What can we learn from the Japanese American incarceration experience, featuring civil rights icon Dale Minami. We're so pleased to have Dale with us today and to have all of you. So we welcome all of you. A note on the Asian American Federal Employees for Non-Discrimination, AAFEN. This is a relatively new organization founded in 2020, which addresses discrimination within the federal government under circumstances where Asian American employees, contractors, service members, and fund recipients come under suspicion as national security risks due to their ethnicity or national origin background. AAFEN provides affected parties with resources as well as opportunities for these federal employees to share their stories with policymakers, the media, and public. AAFEN has briefed or provided consultations for members of Congress and staff, congressional committees, the White House offices, and the Congressional Asian Pacific American Caucus, as well as the Biden transition team. A C3 nonprofit AAFEN is entirely run by volunteers who are currently or former employees who have held senior roles in the intelligence community, as well as allies. I would like to invite our organizers, co-organizers to advance the next slide so we can acknowledge co-hosting organizations. They are the Asian American Foreign Affairs Association, AAFAA, the U.S. Department of Commerce AAPI Employee Resource Group, NOAA, the Native Hawaiian and Pacific Islander Employee Resource Group, and GSA's Asian American Native Hawaiian Pacific Islander Employee Resource Group. We also want to acknowledge support by the Civic Leadership USA. Our agenda is as follows. We're going to welcome a special guest, Rebecca Lee, to make opening remarks. We will follow that with a 30 to 45-minute presentation by Dale Minami, and then follow that with a Q&A. During the presentation, please feel free to input any questions that you might have into the chat. And during the Q&A period at the end, we will address as many as we can. So in order to do that, let's get started. I'd like to introduce our special guest now, Rebecca Lee, who is Deputy Director of the White House Initiative on Asian Americans, Native Hawaiians, and Pacific Islanders. In this role, Rebecca supports the coordination and implementation of federal programs and initiatives to advance equity, justice, and opportunity for AAPIs. Rebecca was previously Communications Director for the initiative under the Obama administration. She has held several public affairs roles at many federal agencies, including the EEOC and HHS, and she was a 2012 Presidential Management Fellow. Rebecca is the daughter of immigrants from Hong Kong and Burma. So pleased to be able to bring you Rebecca. Rebecca, welcome, and we look forward to your opening remarks.
Thank you to my dear friend Ariane for that wonderful introduction. It's an honor to be with everyone today. As Ariane mentioned, my name is Rebecca Lee, and I serve as a Deputy Director at the White House Initiative on Asian Americans, Native Hawaiians, and Pacific Islanders. For those in the audience who are dedicated to public service, whether that's in government or in advocacy, the theme of today's event brings us special meaning and purpose. So I wanted to spend this time to honor the life and legacy of the late Fred Korematsu, who was a true civil rights icon and hero. And it's also such a privilege for us today to hear from Mr. Dale Minami. At 23 years old, Fred Korematsu bravely defied President Roosevelt's executive order that forcibly and wrongfully removed more than 120,000 people of Japanese descent from their homes into incarceration camps throughout the country. Mr. Korematsu went into hiding in Oakland, California, where he was later arrested and convicted of violating that federal order. He sought justice through our legal system for years and years, but lost case after case. Despite these setbacks, Mr. Korematsu never wavered in his pursuit of justice. It took decades for the recognition and apology of the wrongful incarceration of Japanese Americans during World War II And it was not until 1983 that Mr. Korematsu's conviction was finally overturned. President Clinton later awarded Mr. Korematsu the Presidential Medal of Freedom. As President Clinton stated, in the long history of our country's constant search for justice, some names of ordinary citizens stand for millions of souls. Plessy, Brown, Parks, and to that distinguished list. Today, we add the name of Fred Korematsu. Today, we not only honor Mr. Korematsu's tremendous legacy, but we also recommit ourselves to protecting the civil rights and civil liberties of all Americans. This is especially important as anti-Asian acts of hate and discrimination continue to occur. And throughout history and into today, our AA and NHPI communities have time and again been viewed as a scapegoat or less than. And that's why last spring, President Biden established the White House Initiative on Asian Americans, Native Hawaiians, and Pacific Islanders to coordinate a whole of government response to advancing equity, justice, and opportunity for our communities. Our work spans the federal government and is in partnership with AA and NHPI community leaders across the country. We're working to dismantle the systemic inequities our communities have faced, from xenophobia and racism to the lack of disaggregated data to language barriers in accessing federal assistance. And we're fighting every day to help our communities that have been hit so hard by the pandemic, by multiple crises. So we may not hear Mr. Korematsu's name often in history books and in mainstream media, but his impact on our nation will never be forgotten. And I hope that we'll be able to honor that today. Let us all remember his legacy by recommitting ourselves to building a more just and equitable America for all. So thank you so much for inviting me to be part of this program. And with that, I will turn it back to Ariani.
Thank you, Rebecca. At this time, I'd like to introduce to you Dale Minami. Dale is a nationally recognized attorney and Asian American civil rights vanguard. He's had an illustrious legal career, and he's been given many monikers: super lawyer, rebellious lawyer, mentor. He, in the Asian American community, has been so deeply involved. He was co-founder of the Asian Law Caucus, co-founder of the Asian Pacific American Bar Association in the Greater Bay Area, the Asian Pacific American Bar of California, and the Coalition of Asian Pacific Americans. As you all know, by now, he was involved in that significant litigation affecting the civil rights of APIs and other minorities, which include Korematsu versus United States, which Rebecca had talked about and that Dale will speak about in further length. As you know, Dale has been honored multiple times over, named Best Lawyer America for 9 straight years between 2014 to 2022 by Best Lawyers. And then in 2019, he also was honored with the ABA Medal, the American Bar Association's highest honor. He is, in fact, the first Asian American to receive that award in the 90-year history. I'm so proud to have Dale come and speak, and proud to be able to call him a friend and a mentor. Dale, please take away the stage.
Thank you so much, Ariani, and nice statement, Rebecca. I appreciate the chance to be here. I really love organized groups of people fighting for social justice. And I think what you've done here is something we never had when I first started practicing in 1972. And so I'm glad that you have these groups here who are now wielding some political power, which is pretty much the name of the game. And special thanks to Ariani. I met her when she was in law school, and that's some 33 decades ago or so. But I'm so glad she stayed with her commitment to social justice. I was going to talk about Fred Korematsu's case. There were 2 other companion cases, and a third one actually, but I'm going to focus on his because that's the one I was most intimately involved with. And his case arose out of one of the great tragedies in American history. the incarceration of 120,000 Americans of Japanese ancestry, some on as little as 24-hour notice, and they were subjected to enormous indignities. They received no trial, no hearings, no charges, and they had no due process rights, no right to an attorney. They were banished from the West Coast. They were taking some of the god-awful places in the country, but first they had to stay in horse stalls in places like Tanforan or Santa Anita, or in Washington as well. And my parents were some of those people who were affected. My whole community was taken from Los Angeles, including my then one-year-old brother. They lived in desolate places in dismal conditions, bad medical care, poor food. They had no rights to speak of. And I think the worst thing was the abject humiliation they experienced by being termed or denominated as disloyal, or folks that are just inscrutable to the point that, we have to incarcerate them all. All branches of the government conspired, in a sense, to create this tragedy. The president issued Order 9066, which authorized the military orders, which led to the exclusion and banishment and curfew. And the Congress passed a law to support that executive order with criminal penalties. Eventually, the Supreme Court weighed in on these in a disappointing decision, ruled against all of the three men who challenged the military orders. The orders were based on what they called military necessity. You can substitute national security for that now in these days. And that was their justification. But the only crime that the Japanese Americans has committed, since no Japanese American ever was charged, much less convicted of a crime in the entire process, they had Japanese ancestry. So young, old, infirm, my then one-year-old brother was sent to the prisons for being a threat to national security. And it was kind of interesting because not only were Japanese not convicted of any espionage, but the people of Hawaii, the Japanese Americans there, were not taken en masse to prisons. And this is where the attack on Pearl Harbor happened, where the largest concentration of Japanese occurred, and where the Pacific Naval Fleet was in operation. So why were they not taken from Hawaii? I think what you'll see historically is it was simply an act of racism times 2 or 5 or 10, which led to their calls for political and economic pressures, which led to the military orders. Now, this was not a historical aberration. 1942, this happened, but Asian Americans were victims of discrimination and acts of violence, lynchings, since they first came to this country in the mid-1800s. First the Chinese Americans, then the Japanese Americans. Not only were there extra legal discrimination, which includes enormous numbers of, or very enormous numbers of acts of violence or incidents, whole cities burned down. But they were subject to laws that were including segregation. They couldn't be in certain businesses. And when the Chinese were excluded in 1882 in the first American law that banned immigration of an ethnic group, Japanese Americans replaced them, and the pattern repeated itself. Initially welcomed as cheap labor, but when they tried to exercise their rights, they were slammed by laws and also, these incidents that we now call hate crimes. In the 1930s, the gathered war clouds over Germany and Europe led to and presaged the attack on Pearl Harbor. 3 men and 1 woman stood up. And again, I'll just talk about Fred. Fred Korematsu was a welder, and he stayed in the Bay Area in San Francisco, or San Leandro, which is near San Francisco, because he didn't believe he did anything wrong. and he didn't believe he did anything different. He had minor plastic surgery, and when we first met him, because we reopened his case, of course, we couldn't tell anything. He looked just like another Japanese American to us. But he also changed his identification. And while his family were excluded from the coast, Fred just decided to stay. He got arrested. He was convicted of violating the Exclusion Act. And so his case went up to the Supreme Court eventually. Two other men, Gordon Hirabayashi in Seattle, Min Yasui in Oregon, and eventually a woman named Mitsui Endo, who showed terrific courage in challenging her confinement, but not the military orders. She was the only one to win her case, too, by the way. I have to talk about the Hirabayashi case. That was heard first in 1943. And the government used these racial characteristic arguments. And it's a evolution or result of the othering of Asian Americans. They did not understand who we were or who other Chinese Americans were, for example. And so they made up these false claims or acted upon the suspicions they had based on the racism that has begin in this country from the get-go. So in Hirabayashi, who challenged the curfew and exclusion, the court eventually ruled against him by saying, we don't have any information because they had no proof, no expert witnesses, no acts of espionage or sabotage, but they made up facts, peripheral facts that pointed to the disloyalty of this particular ethnic group. Japanese Americans had dual citizenship. They were sent to the mother country for education. They worshiped a, quote, foreign religion, Shinto, language schools. They were unassimilated. And that unassimilation, which of course was promoted by racially restrictive laws, led to another ridiculous conclusion that they were pretty hostile against the United States government because they were discriminated against. Well, the logic of that escapes me. But in the end, they upheld the military orders by a very, very weak decision. And you could tell it was weak because of the use of the language. They used the dreaded double negative, the bane of English teachers everywhere, saying we cannot reject as unfounded the judgment of the military authorities that there were disloyal members of that population whose numbers and strength could not be precisely and quickly ascertained. Well, if you don't know how many there are or who they are, how can you just accept this bald accusation? And so there's a couple other places they use a double negative. It really is not amusing because of the tragic consequences, but it was a very, very weak way to say things. And concluded in a way that during times of war, ethnic affiliations determine your loyalty. Of course, they didn't apply that to Germans or Italians, because what this was a resuscitation of the old inscrutable argument that these are Orientals, quote Orientals. We don't understand them, so they can't be that loyal, and therefore we have to just accept the military judgment. It was a total abdication by the court of the role as independent evaluators of the facts and a complete capitulation or deference to the military judgment. Min Yasui's cases on a curfew was just a companion case that was affirmed for the same reason they affirmed Hirabayashi's conviction on the curfew. And then Fred Korematsu's case came up a year and a half later. And his case was a bit stronger because he not only challenged the exclusion, he challenged the entire detention. There was a whole program of incarceration that started with curfew, then exclusion from the West Coast, and then detention in these God forbid places in 10 prison camps around the country. My parents went from Santa Anita Racetrack in Los Angeles to the swamplands of Arkansas, Aurora, Arkansas. And in Korematsu, they did similar language, only they elevated the magniloquence to mask the terrible tragedy that they were simply upholding. They said these beautiful words as if the words could mask this travesty of justice. All legal restrictions which can curtail the civil rights of a single racial group are immediately suspect. Only the gravest imminent danger to public safety can justify such deprivations. So they say all these beautiful words, and then they turn around and just reaffirm their deference to the military, use the double negative again. And what's remarkable to me is they simply avoid the issue of race. And in a remarkable circumvention, the Chief Justice says Korematsu was not excluded from the military area because of hostility to him or his race. It was a blatant misrepresentation because clearly that was the only reason he was excluded. He was a loyal American, never been to Japan, barely spoke Japanese actually, and tried to enlist in the military, but was denied. And it's as if they were closing their eyes just to believe what was happening was true. And another boggling, illogical statement. They talked about the presence of an unascertained number of disloyal members of the group, most of whom we have no doubt were loyal to this country. Well, they had no evidence, so they had to just make up stuff like, okay, we don't know who they are, but we kind of think they're disloyal, so therefore we're going to put them all in prisons. And later they say they will decide the constitutional questions because they didn't, of detention, because they didn't rule on the imprisonment. Later on, ex parte Endo, Mitsui Endo, a woman in Sacramento, a DMV, a Department of Motor Vehicles clerk, challenged the decision. Eventually, she was released, but she refused to be released right away because the court was still deciding her case. So she had the courage to stay for like 6 extra months so her case would stay alive and vibrant. In Fred's case, there were, or go back into Hirabayashi, it was an 8-0 decision. In other words, 8 justices voted to affirm and 0 dissented. But in Fred's case, there were some vehement dissents. People like Justice Murphy said about the exclusion, it goes over the very brink of constitutional power and falls into the ugly abyss of racism. I dissent, therefore, from this legalization of racism. Justice Jackson, in his famous dissent, says the court for all time has validated the principle of racial discrimination. The principle then lies around like a loaded weapon, ready for the hand of any authority who could put forward a claim of urgent need. These cases were probably the most criticized next to some of the other cases that upheld segregation and upheld slavery. And Korematsu becomes one of 2 modern American cases in legal history that upholds a racial classification. The other was Hirabayashi versus the United States. 30 years pass. The Japanese Americans try to go home and rebuild their lives. They're given $25 and a ticket back to the West Coast. Many decided not to go to the West Coast because it was too dangerous. But during the 60s, the civil rights movement ignites the imagination of Japanese Americans and causes an enormous desire to make the American Constitution live up to its promise. And so the redress movement is born. It was born out of the idea that what was done to Japanese Americans was unconstitutional, and if not unconstitutional by the Supreme Court standards, was absolutely immoral. That there was not enough evidence to imprison all of us and to send us to confinement. So this redress movement was an attempt led by Japanese Americans in enlisting all rainbow coalition of people to try to get Congress to admit they were wrong, the United States government was wrong, give $20,000 in an apology. And it was about this time in early 1980, two very different people met in the archives. One was a professor at Amherst, a Caucasian named Peter Irons, who was a lawyer and a political science teacher. The other was a housewife out of Los Angeles named, Aiko Yoshinaga Herzig. She was on a mission, and it was a personal mission to understand why was I taken away, plucked out of my high school before I could graduate and sent to these prisons. So she just embarked on her own personal journey to find out what was the real reason. What they discovered was remarkable. And this was in the early 1980s. They found these boxes of cases that were never opened, and they were the case files of Korematsu and Hirabayashi and Yasui. And in those case files were memos from the attorneys who handled the case for the United States government. And there was all kinds of other evidence. And in these boxes, they found three separate categories of evidence that would have exonerated Japanese Americans, but they were altered, suppressed, and destroyed so that the Supreme Court never saw the light of day. One set of records was a series of reports by a naval commander named K.D. Ringel, who was charged with investigating Japanese Americans, and he did so for several years before even Pearl Harbor, and to determine, what is the recommendation he would make. And after exhaustive research, he decided that these people are not less disloyal than the rest of the non-Japanese American public, that they should not be taken away en masse, that they should be given in individual hearings. The second set of evidence, but of course, this set of documents was suppressed from the Supreme Court, despite the fact that government attorneys knew about it. There were other claims of espionage and sabotage by Japanese Americans. And it turns out that the evidence that was discovered about the sabotage or espionage, was non-existent. In fact, two federal agencies, the Federal Communications Commission and the FBI, investigated every single claimed act of espionage, of signaling to Japanese ships off the coast. They concluded that every one of them was false, that they were not signaling Japanese ships or ship to shore. What they were doing, they were so incompetent, they were fastening on Radio Tokyo. They heard Japanese, they figured, oh, okay, we have no Japanese translators here, so they must be committing espionage. That information was submitted to the Supreme Court, except that it was not the part that the investigation proved that they were false was not. That was deliberately suppressed. What's interesting about these pieces of evidence was that the lawyers in the Department of Justice, there were several ethical lawyers who said, look, we need to tell the Supreme Court. What we're submitting to the Supreme Court, they said, are deliberate lies. And it's highly unfair to this minority group that these lies go uncorrected. We are approximating the suppression of evidence, and it is highly unethical. Well, those memos that were written to the Solicitor General, the person who argues the case in the Supreme Court, were suppressed. They were not seeing the light of day. And despite the efforts by these lawyers to appraise the Supreme Court, that they had contrary evidence that Japanese Americans were disloyal, that they were committing espionage and sabotage, they were submitted to the Supreme Court. The original lies. There was one other set of or piece of evidence that was critical. It was found by Aiko Yoshinaga Herzig. And it was a report by a man named General DeWitt. He was the one who authorized the banishment of Japanese Americans, the exile of that race. And he wrote a final report. And this report was supposed to be the justification for why we exiled this whole race of people. And that report found its way in the Supreme Court, and it was the one that claimed that there was espionage and sabotage. But it had one other really interesting sentence in it. And that one sentence was discovered by Aiko Yoshinaga, because the original 10 reports, which were sent to the Department of War, the report said, look, it's not a matter of time or urgency that we have to incarcerate these people. It's just that we cannot tell the sheep from the goats. What that meant was these people are inscrutable. No matter what you do, you cannot decide whether they're loyal or disloyal. Okay? I mean, this sounds very underlying some of the issues today that include, Chinese spies, Chinese American spies, and many other issues too. So when that statement hit the War Department, they said, you got to change that. The Supreme Court will never buy that. That's absolutely racist. And there was a big fight, and eventually they changed it to 180 degrees difference from, it's not a matter of time. We have plenty of time. We just can't decide these people. They're inscrutable. And that was changed to exactly the opposite. We didn't have enough time to do this. And then what happened was interesting. The 10 copies of that book were actually burned. And there's a certificate by Army personnel said, we burned the 10 copies. But it was strange because one copy remained. And Aiko found it. And Aiko looked at it. And Aiko read it word by word. And Aiko found that they had made this alteration. They destroyed the other evidence. And yet this one copy remained. I guess some bureaucrat probably figured out, oh, wow, this is really heroic what we're doing here. And I want to keep this because it's so important. And yet it became the linchpin, the centerpiece of our case to get the convictions overturned. So in 1982, I received a call from Peter Irons. He's a professor. I had known Aiko, but I didn't know years before, but didn't know she was involved in this. But Peter tells me he finds this evidence that the United States Supreme Court was lied to, that a fraudulent record was created to win these cases at all costs. Well, not knowing him, I thought that was pretty remarkable. I had volunteered to see if there's in research whether there's ways that we could overturn those cases when I was in law school and shortly thereafter. But this is 10 years later. I get this call and I'm thinking, okay, show me the evidence. And we assembled our work team here in San Francisco, and we looked at the evidence, and it was mind blowing. I mean, there's other words I could use, but this evidence was unknown until Peter and Aiko discovered it. And it formed the basis of our claim that we should reopen these cases. We should reverse these convictions that were affirmed by the United States Supreme Court by alleging that a fraud was committed on the Supreme Court. These were allegations, to our knowledge, were never, ever made in American jurisprudence before. The Supreme Court was lied to. And as a result, people served time in prison. It justified the incarceration of 120,000 Americans of Japanese ancestry without due process. So we had to form 3 work teams because the convictions where the courts where the convictions occurred, those venues were the ones to hear these cases. And so we formed one in Portland and one in Seattle. And we coordinated the cases because we wanted to get the very best judge we could possibly get. And that would mean, federal appointments, not federal appointments, the federal choices of judges are based on pretty much random. And so in those days, they had like a little bingo ball cage, and you'd pull out a paper or ball, and that's the judge you would get. So we knew luck was very much a part of this, although, lawyers don't like to claim bad luck unless you lose a case. But as we carried these huge petitions across the Bay Bridge I lived in Oakland at the time, to file this monumental petition, we got in line at the toll plaza at the Bay Bridge, and got to the shortest line. Of course, somebody ahead of me was paying by pennies or nickels or something, and it took forever. And I was telling Peter, he was with me, I said, you know, I've never been lucky at these kind of things. Like, I never won a raffle. I don't win prizes. He goes, me neither. I go to the grocery store. I get in the shortest line. I guess we're just unlucky. And then our eyes opened wide because we knew that luck was going to be a factor. We took the petitions to the San Francisco United States District Court for the Northern District of California, gave it to a person that we felt was lucky. It was my associate named Lorraine Bonai, who, by the way, has written a biography about Fred Korematsu, a beautiful one. And she knew what was at stake. She files these piles of petition. The clerks know what are at stake. They turn around and they say, you got Marilyn Hall Patel. And she was our very first choice. But before that, the court clerk had to come out and say, you know, what is this? Coram nobis, you're filing. And we explained. He goes, you know, I haven't seen one of these in 30 years. I said, well, here's the 31st year and you're seeing one. So we were very lucky to get this judge. And the idea was to have San Francisco go first because we had the best chance of winning there, best panel of judges to pick from. Seattle would be second. Portland was just a terrible place. But no offense to Portland, the Portland District Court, I meant, Oregon District Court. And we were planning to submit staggered petitions to see who we can get the best judge first. And we'd stall the other cases if we got a bad judge, and we accelerate the good judge case. But we didn't have to stagger too much because we got Marilyn Hall Patel, and she was both smart, she was tough, she was courageous, very sympathetic to people of color. Her last name is Patel. She's Jewish American, but she's married to a South Asian. She calls herself the Asian member of the family, or excuse me, part of the Asian family, she said. So we proceeded with our case. At one point, they offered us a pardon, and we communicated it to Fred. Fred said, no, I'm not going to accept a pardon. Then they came back with a second offer. We're going to offer him a pardon for innocence. And I talked to the opposing counsel, a U.S. attorney. I said, what's a pardon for innocence? We've researched this. We've never seen that. He goes, well, we just made it up. They wanted to get rid of this case. It was an embarrassment. We had super strong evidence. And so we took that suggestion to Fred. And Fred and his wife, Catherine, said, you know, we're not going to accept any pardon. If anything, we should pardon the government. And with that strength of character, which he demonstrated throughout our case, he and his wife and his family, we were able to proceed. We set a hearing date, and we plan to go to court to present our case. All of this was done in the context of that redress movement I mentioned, a huge political movement to get redress for Japanese Americans. And the opponents of redress in Congress were saying things like, well, you know, the law is settled. The Supreme Court already ruled against these men. And the proponents like Norman Mineta and Danny Noe and Robert Mitsui didn't have a great response to that, except that, well, we know those cases are wrongly decided. They're highly criticized. What we wanted to do was get a judicial declaration that what was done in those cases was a fraud on the court. And therefore, those decisions were not just weakened, they were suspect, and they were just based on a foundation of facts that when you sweep away, the law crumbles after that, like a house of cards. So at that time, bills were in Congress, and a Commission on Wartime Relocation and Internment of Civilians was created. And it was created to investigate the entire incarceration, curfew, banishment, and make recommendations if they should get any monetary compensation and apologies. Well, several bills had failed before, but by the time the momentum grew with for example, members of the famous 442 in the Military Intelligence Service, Japanese Americans who gave their lives for this country, where their people were incarcerated in prisons. They testified, and they encouraged other American groups like the VFW, Veterans of Foreign Wars, and the American Legions, traditionally very conservative groups. And they were fighting not just for redress and reparations, they were fighting for our Constitution, to give it strength back that it was sapped by these terrible, terrible decisions. So just about that time, we were able to get move forward. We had a hearing finally, and it was about the time the commission report came on that said that the broad historical causes that shaped the exclusion and detention were race prejudice, war hysteria, and a failure of political leadership. So on the date of November 19th, 1983, we had our hearing. The government had not admitted a wrongdoing, and our job was to get a declaration from the judicial branch of the government, because the executive, Gerald Ford, had repealed the order and wrote that this was wrong. Congress has spoken by creating the Commission on Wartime Relocation and Internment of Civilians, but the courts have never spoken. And so we had this huge gathering of people. It was interesting, the Judge Patel moved her courtroom to what they call a ceremonial courtroom. It was just a much larger with a greater capacity. Hundreds of people came, and most of them, besides the press and a lot of attorneys who were interested, our legal team, the legal teams from Portland and Seattle. But then in the crowd, in the seated, were a lot of former incarcerees, Nisei, second generation Japanese Americans were taken to these prisons and wanted to have their day in court because they never did. So Fred gave them their day in court. And I was able to open the argument by saying, we are here today to seek a measure of justice denied to Fred Korematsu and the Japanese American community some 40 years ago. And I went on to recite the evidence we had, which was very powerful. I was able to demand or argue for a demand to have a judicial declaration that what was done to Japanese Americans was wrong. And that was important because that was the ammunition our proponents in court needed. Fred spoke, and he spoke eloquently about doing this not just for myself, but so that this will never happen to Japanese American, any American again. The court then found that exactly like we wanted, there was no military necessity to imprison Japanese Americans. The government deliberately omitted relevant evidence and provided misleading information in papers before the court. And the facts for the military justification were unsubstantiated facts, distortions, and the representations of a military commander whose views were seriously infected by racism. She ruled that the proceedings in the Supreme Court was fundamentally unfair. With that, she vacated Fred's 40-year-old conviction. And so that was the first declaration that no military necessity existed. And her written decision was both prophetic and wise. She wrote at the end, Korematsu stands as a caution in times of distress. The shield of military necessity and national security must not be used to protect governmental actions from close scrutiny and accountability. It stands as a caution that in times of international hostility and antagonisms, our institutions, legislative, executive, and judicial, must be prepared to exercise their authority to protect all citizens from the petty fears and prejudices that are so easily aroused. So with that, we won our case, and the government appealed. They dropped the appeal, and it became, at least the law of the case at that time. Both Yasui and Hirabashi won their cases, although Gordon, his case had to go to a Ninth Circuit appellate court to win his. Eventually, all three men were awarded the Presidential Medal of Freedom for their courage in fighting these unjust orders. And in 2013, a remarkable confession of error was issued by Acting Solicitor General Neil Katyal. And if you could read it, he just basically says, look, we made a mistake. We committed a fraud on the court. We suppressed evidence. And what was done to these men was unfair. In the aftermath, I think we learned so many lessons that, our government institutions are fragile, and we need to fight to keep our civil rights. They're not gifts, they're challenges, and nobody gives you these rights. So we must be able to stand up. You cannot trust completely the institutions. Look at the Supreme Court right now, the controversy it's engaged in. They say it's not a political institution. It is highly political. Look at what's going on with the decisions that are being made. And that these incantations of national security can be outright lies. Just think for words. Weapons of mass destruction, which justified a war. These things are not something that we can just trust on the face of it. Although we'd love to trust our government institutions, we've learned from history and experience that they don't often treat us fairly. And by us, I mean Asian Americans and Japanese Americans. I think we are victims of that river of racism that overflows every now and then in this country since the beginning and the start of this country. And so it doesn't go away. Sometimes it runs underground, but when it overflows, then you see the otherness that is promoted, that Asian Americans, Asian Pacific Americans are not like, quote, us, and therefore they're more suspect. And so that means that they will racially profile, which happens to the Chinese American scientists, what happened to Japanese Americans during World War II, which has happened in hate crimes on the street. So this common cause, it's very simple, but it's complicated. The simple part is that this is really a result of the racism that we've seen throughout history. The complicated part is how do you counter that? One is political power. We saw that when Japanese Americans were alone during World War II, and we suffered a civil rights disaster. But in 1988, when the redress movement succeeded, it was a rainbow coalition of people wielding political power to demand justice from this government. And we stood up to the United States government, the most powerful nation in the world, and that country, our country, admitted it was wrong. I think, I talked about the spy scandals. We talked about, Wen-Ho Lee, how he was essentially framed, and we see this over and over again. But there are lessons about dissent too, because Fred, Gordon, and Min in 1942 were considered pariahs. They were ostracized, and they had to suffer great isolation. But when they brought their cases in the 1980s, they became heroes. And its dissent is sometimes the highest form of patriotism. It's a political birthright. It's our duty to dissent because that's what the Constitution demands. There are also instances or examples or lessons about individual courage. People like Fred and Gordon and Min and Mitsui Endo, who endured 6 more months in prison just so she could make her point in a court of law. But again, I think what we see today is that echo of history. We see Trump versus Hawaii capitalizing on anti-Muslim fears to create a decision which on one level appears to be very benign by saying, Korematsu is bad law, we disavow Korematsu. We have a system of governments and rights here, and yet in the same breath, Justice Roberts then upholds Trump versus Hawaii, despite Trump's obvious prejudice against Muslims that he announced and declared before he submitted the executive order. So I guess in the end, it's all up to us. It's up to us to be organized. It's up to people like you who have created these great organizations to stand up and speak out. I think until we develop the political power, we're not going to be able ever, I don't believe, erase racism in this country. But the best thing we could do is counter it through political power. The culture of this racism runs so deep that the long-term complexity, as I mentioned, is to change hearts and minds. And maybe that's possible years and years from now, but it's being stirred up by demagogues who want to use this factionalism, these fractures, to empower themselves. And I think that is despicable, and it does terrific damage to our country. So bottom line is, if we could love each other and all that, I'm not a big fan of love as a solution, only the solution to fighting racism when you're getting beat up in the streets. I do believe that you have to exert political power to alter the both perception of who Asian Americans are and the perceptions of others. And that's a long-term cultural and difficult process, but I think we have no other choice. So I think in the end, we need to do what Fred Korematsu says, that if you see something wrong, you got to speak out. You got to do something about it. And I feel that we all need to do that in order to survive and thrive in this country. So thank you very much. I'm proud to be part of this. I'm glad to be here, and just thank you, Ariani, for all you've done and all you keep doing.
Thank you, Dale, and also for the legacy that you have created with Fred Korematsu for all Asian Americans. Just doing a time check, I want to make sure that we have you for another 20 minutes for Q&A.
I'm fine. Actually, my schedule's changed, so I have two daughters that I usually pick up from school, and it turns out that this is spring break, which means they're still here playing on their computers downstairs. So I'm good.
Oh, good. Excellent. Excellent. So for our audience, we are moving to the Q&A period. And so we will be on until it's 4:25 Eastern Standard Time till 4:45. So let me pick a question that talks about the origin, even before the incarceration. It's a question here. Let's see. And it's a history question, so I'm not sure, Dale, if you know, but did the Nihao incident December 7th through 13th in 1941, in which a downed Japanese pilot involved in the bombing of Pearl Harbor was harbored and protected by a Japanese couple on the Hawaiian island of Nihao. Okay, I don't even know if I'm pronouncing that correctly, but was that incident the catalyst for the incarceration of Japanese Americans on the mainland?
Oh, not at all. That was in Hawaii, for one, and Hawaiians were not put away. That incident was overblown. It was overblown by Michelle Malkin, who's an apologist for pretty much white supremacy. And it involved a Japanese couple that found an injured airplane pilot from Japan. And so they took him in, but they didn't show any kind of issue of loyalty or disloyalty or whatever. That they eventually, I think they committed suicide, but it was one incident that occurred a little while after. But the whole motivating factor was both in the mainland and was racism. It was economic interests of farmers who wanted to take over Japanese American lands. It was politicians who just capitalized on anti-Japanese feeling to get elected to office. I mean, this is how Earl Warren got elected governor. He was an attorney general, and then he became a governor when he started saying that, the fact that there has not been any incidents of sabotage or espionage is a disturbing fact that it will happen soon. So he rode the anti-Japanese sentiment to become governor, and then the Supreme Court justice. He became Chief Justice. He became a brilliant, wonderful Supreme Court justice. And before he died, he recanted the statements he made. So Ni Hao is just blown up way out of proportion. It wasn't, people in the mainland didn't even know about it. So it was not, it's a straw man that's been used to justify the fact that there was a good reason for taking 120,000 Japanese on the mainland to prisons.
And thank you. So now I want to turn to another question about military necessity. From what you said, it sounds like the policies were fear-driven rather than based on actual evidence, right? So the question is whether the government could invoke again a similar discriminatory action based on race or ethnicity, so long as there's perceived to be a military necessity to do so.
Yeah, I don't think there's any question they could. Despite what the law says, look at the law said you got to give people a hearing. If you're going to imprison them, you got to give them a trial. Well, they didn't do that. And it's what Anthony Scalia said years ago, that in times of war, the laws fall silent. So it's a matter of political power more than anything else, that if the government wants to do something, it can do it. And the only thing that'll stop them, is the exercise of political power and resistance. So I do believe that it could happen again, despite Robert's hollow words in Trump versus Hawaii, that, Korematsu is overruled by the court of history. Well, it wasn't overruled by the Supreme Court. So it wasn't clear that the Supreme Court recanted it and disavowed it, but it didn't directly overturn it. And even if it did, well, courts look at Roe versus Wade. There's very decent chance that the Supreme Court's going to overrule that. So, what does precedent mean? It means whatever political power is exercised against a specific issue or for a specific issue. So the answer is yes, it could happen again.
So in other words, the case law, the Supreme Court case law stands as long as there's a military necessity rationale. The government could even go as far as incarcerating another peoples based on their.
I believe you can, but like any movement or any kind of policy, the more resistance you put up against it, whether it's political, and I've talked about politics, but even legal too, the more that Korematsu is recanted, the more that it's criticized, the more that Hirabayashi, other cases too, are criticized. That's just another hurdle that an arbitrary authority has to overcome to accomplish some dreaded civil rights violation. So I'm not saying it has no effect at all. It's important to have those kind of statements and declarations on the books. It's important, just as important, or maybe more, to educate Americans about what a tragedy this was, and is just as important for folks to stand up and speak out and do something, not just, oh yeah, okay, that's wrong, and do nothing.
I hear you. So community education and
Yes.
Civic engagement are as important, although the law is still on the books. Now, turning to that, did you consider, after the success, of getting the conviction vacated? This was at the U.S. District Court for Northern District of California level, right? Was there any conversations by you or your legal team to challenge the law itself, the military necessity argument?
We tried to do that, but the law is pretty clear that quorum nobis is the vehicle we use, Latin words for in your court, is Old English writ. That's why it's so obscure. Requires that you go to the court of conviction. We thought of filing in the Supreme Court, Ninth Circuit, but we chose to take 3 bites out of the apple: Portland, Seattle, and San Francisco. So while we included in our petition a request to invalidate a Supreme Court decision, the district court did not have the authority to overturn a Supreme Court decision. So we had to look for similar cases afterwards. Hamdi versus the United States, the Guantanamo cases were good examples. There are a few more we filed amicus briefs in to ask the court to overrule. We actually wrote a letter directly to Donald Verrilli, the Solicitor General, during, I think it was the Obama administration, asking him to make a declaration that Korematsu is overruled or discredited more. So Trump versus Hawaii became the very best opportunity we had. And the kind of, I guess, malfeasance, I would call it, and inaccuracies that Roberts put forward in his majority opinion were not too dissimilar from Korematsu. In terms of, he said, well, there's a report out there that we can't see, but we're going to rely on it anyways, what the government says about the danger of certain members of certain countries or citizens of certain countries immigrating here. So he allowed the suppression of evidence there. He made the grandiloquent statements about rights that he just totally disregarded. He even made some misstatements where he says that we're not going to look at the outside, not misstatements, but kind of ridiculous statements about we're not going to look at any outside evidence. Not Trump stating that Muslims don't belong here. I'm going to put a complete ban on them. Racist statements. He just disallowed any kind of that evidence as part of the consideration. And then he said something really lame. He says that we have to look to the four corners of this executive order. And just like before in Korematsu, it's never we never they didn't mention Muslims by name, and that's critical. Well, that was true of Japanese Americans too in Korematsu. The executive order doesn't say Japanese in there or Asian. They never do that. It's too obvious. So he just kind of misstated the fact that was the same case as in the Trump versus Hawaii. So bottom line is that Korematsu is discredited more, which is good. The bad part is the worst precedent was that, look at whatever the executive wants to do, we're not going to question. And that is almost what he said and almost what the decision says. It's the same as Korematsu.
Yeah, we've been talking a lot in legalistic language, and so just to summarize, there's a question from Sam Mihara, World War II camp survivor, and so he wants to know if the Korematsu case was overturned in Supreme Court. So would you like to just clarify the distinction between vacating Korematsu's conviction and at the Ninth Circuit versus the original Supreme Court case?
Yes, so the law that was created by the Supreme Court in upholding the detention, the banishment and curfew was resulted in the affirmance of the conviction. You could overturn a person's conviction, but you can't overturn the law specifically if it's issued by a higher court. So while we were able to use this writ of error coram nobis to overturn Fred's conviction, we're not able to overturn a Supreme Court legal decision. So it's kind of a technical distinction, and people get confused a bit about that, rightly so. But the federal laws only allow us to go in to overturn the conviction itself and not the law that was created by the Supreme Court. I'm glad Sam's here online too. He's terrific.
Good, you have a friend there in the audience. Question from Lynn Hamamoto from Cincinnati. This is about the ICE detention centers. So Nakamoto group was a federal contractor.
Right.
Came out with a report after review per an inquiry by Senator Elizabeth Warren in 2019. She's wondering if you knew about the outcome.
You know, I don't know if they actually revoked her contract. This is a woman who owned a detention center, and she tried to justify her ownership of these horrible detention centers by saying, well, you know, my people were put into incarceration camps too. Well, you know, two wrongs don't make a right. So, I mean, for her to engage in the horrific treatment of these immigrants, in my mind, was not only a feeble, it was ingenuous. You know, she wasn't in prison, and even if she were, that's not a justification to imprison some other people. So I don't know. I know there's an effort to divest her or take away her contract, but I don't know what actually happened and whether she was. I think some new laws came into that affected the number and size of these camps to these ICE prisons, I should call them.
I want to turn back to loyalty now, the issue of loyalty. So, today, loyalty is not as crassly defined, on heritage alone,
Mm-hmm.
but in practice, it's close. So what are used now are policy and practice terms such as quote unquote foreign preference and quote unquote foreign influence. So basically what that means is that if you have family ties, travel to Asia, you have business ventures, you inherit property interests like inheritance, or you have these social cultural exchange programs, things that Asian Americans do by virtue of the fact that 71% of Asian American adults are foreign born, right? So in the nuclear family, there's still these connections, yet those activities are regarded as national security indicators used as the basis for investigations for determining whether you get federal funding, whether you can maintain your security clearance, for determining assignment restrictions for diplomatic posts. And so not all Asian Americans are affected, but especially if they are working in these sensitive positions or handling sensitive materials, they have an increased chances of encountering these barriers. We heard numerous complaints, but they're generally very quietly made. I wanted to know, well, first of all, it calls into question who gets to define loyalty, American loyalty, right? And so how would you respond? And more importantly, what advice would you give to an audience who want to challenge this sort of outdated Western-centric view of loyalty?
If you look back at the Korematsu case or Hirabayashi case especially, I cited all those factors because it bears on what's happening today. They use these indicators of loyalty, unassimilated. You send their kids to foreign countries, different religion, different language. So these are peripheral facts. They were not like owning or being a part of the KGB, for example, before. And so, the court not the court, Americans have done this since the start. They treat people, especially Asian American, not especially, but Asian Americans with suspicion because they are ignorant about them. And so they'll look at these peripheral facts to then, in Hirabayashi and Korematsu, justify massive incarceration, racial profiling. Today, I think if they could find valid connections between certain factors, could be only land, it could be anything else, and with loyalty or criminal activity or espionage and sabotage, well, I think it's got to be more science-based or data-based. And if you find those connections and you find a correlation between certain factors and quote, disloyalty, allegiance to your country, primary allegiance, yeah, then maybe you could apply it. But the trick is you got to apply that equally. So what about Russia? How about Russians in this country? Are you going to do the same to them? How about, Germans or we saw some spies convicted who were Caucasian. So any of those countries, will you apply the same standards to them? So I think it's got to be data driven. It's got to be based on some correlation that is proven to be accurate as far as predicting criminal behavior. And you have to apply that across the board. And I think the third part of that is got to be transparent. I mean, of course, you can't have all transparency if it's like true national security, but you've got to give up enough that we know that what you're not saying is that, oh, they're inscrutable, or they're saying things that, oh, you go to Japanese language schools or language schools. So we need enough information to be able to test whether the data-driven basis for their declarations or their verdicts are correct.
So last question, you talked about the allegations have to be evidence-based. There was a recent congressional inquiry into a security office at the Department of Commerce. This was named ITMS. I don't know if you've read in the newspapers, but this was an office that overstepped its authority and opened up investigations. Many of them of their targets of investigation were Asian Americans. There's a participant who asked what lessons could be drawn from the Korematsu case that could be applied to these investigations.
Oh, I'm not sure how to answer that question. And I don't know what that investigation was. If it were truly weighted against Asian Americans, and if the factors they used were not indicative of or predictive of certain behaviors involving espionage, yeah, that's a problem. I think what is important is going back to the basics, and that's to wield some type of political power or influence. So when you organize groups like you all done here, I think that's a counterweight against government abuse. But it's got to be broader than that. It's got to be connected to a larger Asian Pacific American community, to the point that others outside of your group in the federal government can exercise the power to call their representatives, senators and congress people, which leads us to the point of political power. Once you could use those levers, I do believe that education is one way to do things, but the other way is just to wield that power to demand an investigation, demand accountability, demand transparency. And I think that's probably the best you can do. Oh, there is one other thing. Make allies in the press so that you can publicize and be able to expose the types of wrongdoing, I think, that are targeting Asian Americans.
Thank you, Dale. And with that, we're going to conclude our program. We'd love to talk to you further, but we'll also want to respect everybody's time. I want to sort of capitalize on something that Dale said, which is to be involved. And, often the Asian American Federal Employees for Non-Discrimination has a website. We invite you to contact us, join our efforts. And, if you would like to join us in sort of challenging these barriers that we've described, the website is www.AAFEN.org. And Dale Minami, thank you so much for your time, your work, your life's work, your legacy. We are indebted to you and appreciate the time that you've also given to share with us today.
Well, thank you very much. Keep on fighting.
We will. Thank you all. To AAFEN, our co-hosting organizations. Also want to give a shout out to Michael Young, Angela Zhang, who's been handling the tech and the questions, and to all of you in the audience. We will hopefully be hosting more webinars and also be issuing a joint newsletter with OCA, Asian Pacific American Advocates. So if you would like to receive that, make sure to go to our website and drop us a note or leave your email here in the chat. Thank you so much, all. Bye-bye.
Thank
Bye-bye.
you, everyone.